So, welcome all of you. Today, we are going to read one very special subject which has been given in your UP Judicial Services syllabus. That is the Medical Termination of Pregnancy Act 1971. So, this is also one very good and social welfare legislation. It is for the welfare of women mainly. This is Act number 34 of 1971. This can be asked in your paper. So before reading any act, you must read what is the preamble of that act. Why that act has been enacted. क्यों वो act लाया गया. What is the very objective of that very act. So as we can see in our bare act, an act to provide for the termination of certain pregnancies by registered medical practitioners and for matters connected therewith and incidental thereto. It means they are saying this act has been provided to us for the termination of certain pregnancies, not all kind of pregnancies, rather certain pregnancies. By whom? By registered medical practitioners. And for matters connected therewith and incidental thereto, which we'll be reading through the various provisions. So let us see some very basic things of this very act. That is the date of enforcement. Enforcement date. Very specific date. You may remember it. By making your own tricks. 1st of April. So what is the extent of this act? In what areas this act extends? It extends to whole of India. Simple. It extends to whole of India. It shall come into force on such date as the central government may by notification in the official gazette appoint. So what is that date? That date is 1st April 1972. So when this date becomes important, some other date equally becomes important, and that is the amendment which has been done in 2021. That is equally important. And the enforcement date for that amendment, I am writing that thing. The MTP Act. Hereby I am saying MTP Act. (2021). MTP Act, Amendment Act 2021, which came into force September 24th September 2021. So this becomes equally important for you. So apart from this act, there is some rule also given in form of MTP, that is the Medical Termination of Pregnancy Rules, and that is of 2003, Medical Termination of Pregnancy Rules 2003, that you also remember. 2003. So no need of just learning the enforcement date of this very rule. Rather, the enforcement date of Act plus Amendment Act is important. That I have already told you. So when we talk about medical termination of pregnancy act, so earlier when we see in India abortion became legal only in 1971 after the enactment of this very act. Earlier, what was the stage? Before this 1971 act, it was taken as stigma, abortion, right? And India did not allow abortion, and it was highly unacceptable. It was highly unacceptable in the society, and it was seen as an stigma, right? But with the changing times and progressive thinking, we adopted some rules. There was also a need of giving protection to the women, right? Be it a single child, single parent woman, right? And so this MTP Act 1971 was passed passed in 1971 with very progressive thinking that this abortion should be given legal significance, legal recognition, so that these women should be protected. So you write, the MTP Act 1971 was passed due to the progressive approach and with the developments being made in the field of medical science with respect to safer abortions. So what does it mean? What does it mean? It means that abortions used to happen earlier as well. Right? Abortions तो पहले भी होते थे. But क्या होता था? It was not legalized in certain conditions. छुप छुपा के लोग कर लेते थे. Abortions तो पहले भी होते थे at some private medical centers or something like that. So this medical termination of pregnancy act legalized certain kind of abortions in certain cases, in certain situations, for which they have given very exhaustive, very thorough provisions in section 3. That is very important section of this very act, right? So now coming to the connection this very act has got with constitution and with other subjects. Now if we connect it with constitution, so very important article comes in our mind, that is article 21. If anybody has, mainly women, has a right to life and personal liberty, then it should be her choice only to whether to reproduce, whether to procreate or not to procreate. In the same manner, if she has certain rights in order to choose whether she wants to have sexual intercourse or not, whether she is going to reproduce or not, she is willing to be a part of that procreation or not, this is whole soul her choice. So she should not be denied with such kind of right given under article 21 domain. बिकॉज इसका डोमेन तो बहुत बड़ा है ना आर्टिकल 21 का, और हमें उसी तरीके से उसको देखना भी है. So this MTP Act provides certain protections. If we see it in connection with IPC, we already know that there is section 312. Or you can write 318 as well. But mainly it causing miscarriage deals with 18. 316, or you write 318. Because they are talking in 17 and 18, morely they are talking about abandonment of child. They are leaving the child at some place, not about miscarriage. Then also I have written 318. So this IPC talks about miscarriage, and therein it penalizes causing miscarriage. It gives punishment, wherein if we talk about this MTP Act, it legalizes this kind of abortions, right? So somewhere this MTP, I'm writing IPC under section 312 till 313 penalizes abortion and punishes both the persons, the woman and the abortionist, right? The one who is doing the abortion. But MTP Act legalizes abortion, but in certain conditions. This you must remember. Certain conditions. So IPC is more of a general act and this MTP Act is more of a special act. So the conclusion we can take out from this is that MTP Act acts as an exception to IPC, to the Indian Penal Code. MTP acts as an exception to Indian Penal Code. So if we talk about the history, कुछ इतिहास जान लेते हैं इस MTP एक्ट के आने के पीछे क्या था. The Indian Penal Code of 1860 prohibits illegal abortions. You can write here penalizes illegal abortion. Yes, illegal abortion. तो सुधार कर लीजिएगा. From section 312 to 318, and willfully aborting a pregnancy is made a criminal offense. After this, adopting several stages have come, wherein adopting a progressive approach towards the reproductive rights of women, and that has been recognized in several case laws as well. The government set up एक कमिटी भी जो आपसे सवाल पूछा जा सकता है एग्जाम में. एनी नेम एनी कमिटी विच हैज बीन formed in reference to this medical termination of pregnancy act. So you must remember Shantilal Shah committee. Government set up the Shantilal Shah committee to analyze the need for abortion law in the country. So this very committee was formed. इस कमिटी को फॉर्म किया जाता है जब ये आवश्यकता महसूस की जाती है कि हमारे कंट्री में एक इस तरीके का कोई एक्ट होना चाहिए जिसमें प्रेगनेंसी वगैरह को अबॉर्ट करने के लिए एक पर्टिकुलर लॉ होना चाहिए. So this committee reviewed the legal, medical and socio-cultural aspects of abortion and recommended legalized abortions and legislations on the comprehensive abortion care. Consequently, the MTP Act got enacted, and you got this very act in this form, and its enforcement date you already know, that is 1st of April 1972. So अभी तक हमने जाना that MTP Act provides that freedom in certain conditions that any woman can abort the very pregnancy. At the very same time, this MTP Act provides some certain restrictions as well, because they are using certain condition word in their preamble itself. It means if they are giving certain right to you, it means that right is not at all free. It is coming with certain restrictions as well. So you must remember that this MTP Act at the very same time just channelized, categorized the whole this abortion, how in what manner it should be done, right? What should be the proper procedure, what is the significance of medical board, what is the significance of registered medical practitioners, what is the significance of taking consent from that very woman. Okay, consent is paramount, is of paramount importance. You must remember that without consent this cannot be done. So you write few lines on this. When I am using the word reproductive choice, you remember K.S. Puttaswamy case. In this very case, this reproductive choice has been taken as a part of right to privacy. Okay. When the MTP Act when the MTP Act enhances the very idea that there should be no restriction whatsoever on the exercise of reproductive choices, in the same manner as a woman's right to refuse the insistence of on the use of contraceptive methods, because this is her particular right which you cannot take away from her. We have recognized several rights of women. As I've already told you that it is her right that she can choose whom she wants to have sexual intercourse. Even she can choose the partner as well, right? In the same manner, her reproductive choices should also be given the recognition, and in the same manner as a woman's right to refuse the insistence on the use of contraceptive methods. At the very same time, it prescribes that termination of only permitted in certain conditions. Hence, the provisions of MTP Act 1971 beneficial social legislation, but with restrictions, but with reasonable restrictions that have been laid down in the exercise of reproductive choices. In the exercise of reproductive choices. So the crucial consideration which we have to keep in mind, and this has been taken care of in this very act, is that the woman's privacy, her bodily integrity should be respected. It should be her choice whether to reproduce or not to. Okay? So हमने ये जाना how this MTP Act is useful for us. You must read the statement of objects and reasons because it becomes important while writing your mains answers. It gives you sufficient material as to craft your answer in a very better way. It can give you extra edge, right? So there are number of sections which is given in MTP Act is 8. Only 8 sections are there, in which section 3 is the foremost one, is very important. So coming to the definition clause. In this act, unless the context otherwise requires, guardian means a person having the care of the person of a minor or a mentally ill person. So it means who are the guardian has been given in clause A. Guardian means a person having the care of the person of a minor. It means they are not taking care of any property of a minor. ठीक है, they are taking care of a person of a minor or a mentally ill person. So they are including mentally ill person as well. Next, that has come through Amendment Act, that is 2021 Amendment Act. AA, Medical Board. Medical Board means the medical board constituted under subsection 2C of section 3 of the Act, that has been given in section 3 of subclause 2C of this very Act, Medical Board. Medical Board. Who can be the mentally ill person? Mentally ill person. इस पूरे एक्ट को पढ़ते वक्त आपको सिंपल कॉन्स्टिट्यूशन से कनेक्ट रखना है, राइट? आर्टिकल 14 से कैसे कनेक्टेड है दैट आई विल टेल यू. आर्टिकल 21 से आपने कनेक्शन देख लिया, राइट? Means a person who is in need for treatment by reason of any mental disorder other than mental retardation. So they are not including any mental retardation, they are just including who is in need of treatment by what reason? By reason of any mental disorder. By reason of any mental disorder. So mainly questions will be asked provision based question, not anything else will be asked in this. C minor you can always read. C is minor. D, registered medical practitioner. Medical practitioner. The registered medical practitioner means a medical practitioner who possesses any recognized medical qualification as defined in clause H of section 2 of Indian Medical Council Act 1956, whose name has been entered in state medical register and who has such experience and training in gynecology and obstetrics as may be prescribed by rules made under this act. Okay, so this is registered medical practitioner, for which the provision has been given in rule 4 as well, right? Rule 4 of MTP rules 2003 E, termination of pregnancy. ये आपको याद हो जाना चाहिए ऐसे ही, क्योंकि यही आप पढ़ रहे हैं. मीन्स अ प्रोसीजर टू टर्मिनेट अ प्रेगनेंसी बाय यूजिंग मेडिकल और सर्जिकल मेथड्स. तो मैंने आपको पहले ही बताया था, हम इसमें जानेंगे सेक्शन 3 which especially talks about the procedure, how this very medical abortion should be taken place. So one case becomes very important in this regard. सेक्शन 3 जो कि मेन है, उस पे जाने से पहले मैं आपको ये इंट्रोडक्टरी पार्ट जितना है वो मैं खत्म करना चाहूंगा. सुचित्रा श्रीवास्तव वर्सेस चंडीगढ़ एडमिनिस्ट्रेशन. So you write, the court said that, in this case, the court said that there is no doubt that a woman's right, in this case, the court said that the court said that there is no doubt that a woman's right to make reproductive choices is also a dimension personal liberty, of her personal liberty as understood as under Article 21 of the Constitution. It is important to recognize that this, I am writing all things whatever I have already told you, right? It is important to recognize that reproductive choices can be exercised as well as to abstain from procreating. From procreating. The crucial consideration is that a woman should be respected. That is how you get the connection with Article 21 of Indian Constitution. अब इस एक्ट को समझने के लिए क्या क्या डेवलपमेंट्स हुए, क्या पहले की स्टेजेस थी, क्या कंडीशन थी, और सेक्शन 3 किस तरीके से इस पूरे एक्ट की जान है, ये मैं आपको बताने जा रहा हूं. व्हेन प्रेगनेंसीज मे बी टर्मिनेटेड बाय रजिस्टर्ड मेडिकल प्रैक्टिशनर्स. व्हेन प्रेगनेंसीज मे बी टर्मिनेटेड बाय रजिस्टर्ड मेडिकल प्रैक्टिशनर्स. सो सिंपली आप जानने जा रहे हैं क्यों, कब कब प्रेगनेंसी को टर्मिनेट किया जाएगा by registered medical practitioners. So they are writing notwithstanding anything contained in IPC. राइट जो भी मैंने अभी आपको आईपीसी से कनेक्शन इसका बताया था, उन्होंने उसको विलुप्त कर दिया. जो भी कुछ आईपीसी में दिया है उससे कोई सरोकार नहीं होगा. राइट Notwithstanding anything contained in the IPC, a registered medical practitioner shall not be guilty of any offense under this code, under that code, or under any other law for the time being in force if any pregnancy is terminated by him in accordance with the provisions of this very act. इस पूरे एक्ट को अगर ध्यान में रखते हुए कोई प्रेगनेंसी को अबॉर्ट या टर्मिनेट किया गया है, then that person who is aborting will not be held liable, and he will not be criminally liable under IPC as well. Okay, because they are writing notwithstanding anything contained in IPC. So whatever is given in IPC, it has not to be made applicable here. So this very clause is clear to everybody. Second, subject to the provisions of subsection 4. इस सेक्शन को थोड़ा सा हम तोड़ के भी पढ़ेंगे क्योंकि इसमें रूल्स भी साथ में पढ़ना है, प्लस अदर सेक्शंस से भी कनेक्शंस है इसी एक्ट में. सब्जेक्ट टू द प्रोविजंस ऑफ सब सेक्शन 4. ये पूरा सेक्शन अगर समझ में आ गया, सेक्शन 3 एमटीपी एक्ट इज कंप्लीट, खत्म, आपकी मुट्ठी में होगा एमटीपी एक्ट. अगर ये सेक्शन 3 कंप्लीट होता है आपका, अच्छे से समझ जाओगे तो, और मैं समझाऊंगा. Subject to the provisions of subsection 4, a pregnancy may be terminated by registered medical practitioner. So simply they are writing pregnancy can be terminated by registered medical practitioner. Kab? Where the length of pregnancy does not exceed 20 weeks if such medical practitioner is. अब यहां इज क्यों लिखा है ये भी मैं आपको बताऊंगा. सिंपल आपको ये जानना है, वेयर द लेंथ ऑफ द प्रेगनेंसी डज नॉट एक्सीड 20 वीक्स. दे आर सेइंग कोई भी प्रेगनेंसी टर्मिनेट हो सकती है जब तक कि उसकी लेंथ क्या हो, डज नॉट एक्सीड 20 वीक्स. 20 हफ्ते से ज्यादा अगर वो प्रेगनेंसी नहीं जा रही है, इट कैन बी टर्मिनेटेड. बाय whom? By registered medical practitioners. Simple. One point. Second point, if such medical practitioner is, it means what are they conveying? यही trick समझ लो यहीं पे. Is word has been used. Is word has been used. It means there is how many number of this registered medical practitioner is there? Only one, because they have used the word is. If such medical practitioner is, right? So that is where you have to take advice of one doctor, and that doctor should be medical registered practitioner. right? So in this, you have got one case wherein pregnancy can be terminated by registered medical practitioner if that pregnancy has not exceed beyond 20 weeks. याद कर लो यहीं पे 20 weeks से अगर exceed नहीं की है तो, okay. Where the length of the pregnancy exceeds 20 weeks but does not exceed 24 weeks, it means कुछ और प्रावधान भी दिए गए हैं कि 20 वीक से अगर अधिक भी हो जाती है बट डज नॉट एक्सीड विद 24 वीक्स, बट डज नॉट एक्सीड 24 वीक्स इन केसेस। तो अब इस पर्टिकुलर पार्ट के लिए कुछ केसेस कैटेगराइज किए गए, राइट? Categorically, they have written case of such category of a woman as may be prescribed by rules made under this act. So that is where medical termination rules become important. Medical termination of pregnancy rules becomes important, right? Rules become important because in that very rule they have written what kind of women are there. कौन सी ऐसी women होंगी जिनको हम इसमें अलाउ करेंगे टू टर्मिनेट दैट प्रेगनेंसी अगर उनकी प्रेगनेंसी इवन दो देयर प्रेगनेंसी हैज एक्सीडेड 20 वीक्स बट इट शुड नॉट एक्सीड 24 वीक्स। तो पहले हमने देखा 20 वीक से पहले का प्रावधान कि कभी भी हो सकती है 20 वीक से पहले, बट देयर हैज टू बी वन मेडिकल रजिस्टर्ड प्रैक्टिशनर। कितना? ओनली वन। In second clause, they are talking about certain special conditions that have been provided in rule, medical termination of pregnancy rules 2003, right? उसमें कहा गया अगर 20 वीक से ज्यादा हो गई है बट 24 वीक से ज्यादा नहीं होना चाहिए, इस केस में प्रेगनेंसी अगेन कैन बी टर्मिनेटेड। अब हम देखेंगे कि कौन से ऐसी कैटेगरी दी हुई है रूल 4 में बाद में। देन एक साथ देख ही लेते हैं, आइए। दे आर राइटिंग Rule 3B, women eligible for termination of pregnancy up to 24 weeks. This is the marginal heading. Till 20 weeks, there is a provision given under subclause A. Under subclause B, they have asked us to refer the rules. So the rule number is 3B. 3B. This is MTP rule. MTP rules 2003. MTP rules 2003. Rule number 3B. Women eligible for termination of pregnancy up to 24 weeks. The following categories of women shall be considered eligible for termination of pregnancy. The following categories of women shall be considered eligible for termination of pregnancy under clause B of subsection 2 of section 3 of the Act. So again they are referring to that very section. जहां से हम यहां आए हैं वहीं को ये रेफर कर रहे हैं कि सेक्शन 3 के क्लॉज सबसेक्शन 2 का क्लॉज बी। फॉर अ पीरियड ऑफ 24 वीक्स, राइट, 24 हफ्ते तक कहीं ना कहीं प्रेगनेंसी को आप टर्मिनेट कर सकते हैं। किस अवस्था में? नेमली सर्वाइवर्स ऑफ सेक्सुअल असॉल्ट और रेप और इंसेस्ट। अब आप खुद ही समझो, one who is a survivor, one who is a victim of some rape or incest, means sexual intercourse within the family members, or any survivor, any minor woman is there. So she has already gone through several things. If she is a victim of this very category, इस पूरे कैटेगरी में अगर किसी भी भाग में वो कहीं ना कहीं फॉल करती है तो इट मीन्स उसने बहुत सफर किया है। नाउ इफ देयर इज सर्टेन चाइल्ड इन हर वूम, और अगर हम उसको इंसिस्ट करें दैट यू मस्ट बेयर दिस चाइल्ड, आप उसको बर्थ दीजिए, सो इज इट नॉट इनजस्टिस टू हर? इज इट नॉट इनजस्टिस टू हर? क्या वो अन्याय नहीं होगा उसके साथ? बस इसी तरीके से समझना है आपको, इसी तरीके से समझना है कि क्यों 20 से 24 के 20 वीक से ऊपर भी ये पर्टिकुलर कंडीशंस दी गई हैं। क्योंकि there are extraordinary circumstances wherein woman is survival of sexual assault or rape or incest. Minors, second. B, change of marital status during the ongoing pregnancy, widowhood and divorce. Right? So certain stigma comes along with whenever there is some divorce happen, say, or in the case of widowhood. Now, it is better not to procreate, or it is better not to give birth to a child. They are mentioning this thing if there is a change of marital status. आपको ये नहीं लग रहा है यहां मैरिटल स्टेटस लिख के इन्होंने इस पर्टिकुलर एक्ट को कन्फाइन कर दिया? क्योंकि बाय राइटिंग दिस वर्ड मैरिटल स्टेटस दे आर जस्ट कन्फाइनिंग दिस एक्ट टुवर्ड्स ओनली दोज वुमेन हु आर मैरिड. बट दिस इज, आई हैव ऑलरेडी टोल्ड यू, मैंने आपको पहले ही बताया है, दिस इज बेनिफिशियल सोशल लेजिस्लेशन. सबके लिए इसको कल्याण करना है, सबके लिए न्याय करना है. सो सपोज देयर इज अनमैरिड parent, unmarried single mother, in form of minor, in form of survivor of rape, victim of rape, incest, uska kya? So in various cases which I have already told you, or I'll tell you later, that this change of marital status should be given a very narrow interpretation. Rather, it should be given a very broad interpretation by including other women as well, जो कि single unmarried single parent. Because you already know that this is violation of Article 14. You are making very special law for one certain community, and that is married women. And the case and the consequence of this very act falls on unmarried women as well. So why don't you give the protection to those women as well? Is it not violative of Article 14? Yes. So that is why you have to include this unmarried single parent as well in this. Thereafter they are writing in clause D, women with physical disabilities. Right? So major disability as per criteria held in Disabilities Act 2016, you can already remember. Thereafter mentally ill women including mental retardation. Mentally ill women को भी इन्होंने include कर लिया. Thereafter next clause, the fetal in malformation that has substantial risk of being incompatible with life, or if the child is born it may suffer from such physical or mental abnormalities like सीरियसली हैंडीकैप्ड होगा वो. तो इस अवस्था में भी क्यों उस चाइल्ड को उस पर्टिकुलर वुमेन को इंसिस्ट किया जाए, जो कि ऑलरेडी इट हैज बीन डिस्क्लोज्ड दैट अर्लियर इट वाज डिस्क्लोज्ड, नाउ इट हैज बीन सीन very clearly, it is very manifest that whatever child who is going to take birth, he will not be normal, he or she will not be normal. Rather, he will be mentally retarded, he will be physically challenged, right? So they are even providing certain provisions, unka bhi this pregnancy of such kind of child can be terminated. So उतना तो एक्ट पढ़ के लेजिस्लेशन, बेनिफिशियल लेजिस्लेशन नहीं पता चला, जितना इस रूल को पढ़ने के बाद आपको यह पता चला कि हाउ दिस वेरी एक्ट इज बेनिफिशियल सोशल लेजिस्लेशन. नेक्स्ट पॉइंट, वुमेन विद प्रेगनेंसी इन ह्यूमैनिटेरियन सेटिंग्स और डिजास्टर और इमरजेंसी सिचुएशंस एज मे बी डिक्लेयर्ड बाय द गवर्नमेंट. सो कुछ क्वेश्चन आपसे पूछा जा सकता है दैट in emergency situation or in any kind of humanitarian crisis, if there was, right, if there any woman who is raped, now there is one child in her womb, now should we insist that she should bring that child into this world? No, that is where they are giving protection. Women with pregnancy in humanitarian settings or disaster or emergency situations as may be declared by the government. So these clauses are there, A, B, C, D, E, F, G, right? 7 clauses are there in which they have made reference that even in such kind of conditions pregnancy can be terminated even though 20 weeks have been passed already. 20 वीक ऑलरेडी पास कर गए हैं, फिर भी आपको अलाउ किया जाएगा इफ योर केस फॉल्स विद इन दिस वेरी रूल, दैट इज 3B. याद कर लीजिए 3B ऑफ मेडिकल टर्मिनेशन ऑफ प्रेगनेंसी रूल 2003. कितने रूल दिए गए हैं? 7 रूल दिए गए हैं. आपको यह भी पता चल गया क्या क्या रूल्स हैं जो कि रेप सर्वाइवर, इंसेस्ट या सेक्सुअल असॉल्ट, माइनर्स, मैरिटल स्टेटस का मैंने आपको पूरा इंटरप्रिटेशन बता दिया. खाली मैरिटल स्टेटस चेंज हो जाए किसी वुमेन का, उसी को हम इंक्लूड नहीं करेंगे. रादर इफ देर इज एनी मटेरियल चेंज इन द सर्कमस्टांसेस, इसमें सब कुछ आ सकता है ना, लिव इन रिलेशनशिप और बहुत सारी चीजें आ सकती है. तो दैट इज वेयर ड्यूरिंग द ऑनगोइंग प्रेगनेंसी, देयर आफ्टर वुमेन विथ फिजिकल डिसेबिलिटी, वुमेन विथ मेंटल डिसेबिलिटी, fetal malformation wherein there is a threat to child, that वो अगर born भी होगा he will not be normal, he or she will not be the normal child. So why to get into such situation, right? कि thereafter mother again will have to suffer, apart from doing all other things she will have to just take care of that child who is not normal. So एक बड़ा challenge उसको और हम और देंगे, तो उससे बचाने की जरूरत है. Okay, coming back to section 3 of the act. सेक्शन 3 में अभी तक आपने क्या जाना, मैं समराइज कर देता हूं. आईपीसी से कोई सरोकार नहीं होगा. इफ एनी पर्सन गेट्स इन्वॉल्व इन टर्मिनेटिंग दिस प्रेगनेंसी एंड दैट पर्सन इज इफ रजिस्टर्ड मेडिकल प्रैक्टिशनर, he shall not be guilty of any offense. Right? He shall not be guilty of any offense in accordance with the provisions of this act, if he is following all the conditions which has been given or laid down in the provisions of this act. Now, secondly, they are saying, अगर 20 हफ्ते तक की कोई प्रेगनेंसी है तो yes, it can be terminated by on the advice of one रजिस्टर्ड मेडिकल प्रैक्टिशनर, वन रजिस्टर्ड मेडिकल प्रैक्टिशनर. राइट. 20 हफ्ते से अगर एक्सटेंड हो चुकी है कोई प्रेगनेंसी और अगर कोई चाहता है उसको कि मैं आई वांट टू टर्मिनेट दिस प्रेगनेंसी, देन हर केस शुड फॉल विद इन द रूल्स दैट इज गिवन अंडर 3B ऑफ मेडिकल टर्मिनेशन ऑफ प्रेगनेंसी रूल्स. याद करना ही नहीं पड़ेगा आपको, अगर मेरे साथ आप सीखते जाएंगे तो कुछ एक्स्ट्रा नहीं पढ़ना है, कुछ भी एक्स्ट्रा नहीं पढ़ना. सिंपल, ट्राई टू रिमेंबर, ट्राई टू अप्लाई योर माइंड ऑन दिस. आप इसको एग्जाम्पल के तौर पे सोचते जाइए, कैसे मैंने आर्टिकल 14 से कनेक्ट किया, कैसे मैंने आर्टिकल 21 से कनेक्ट किया. आप भी होते तो शायद यही करते, आप भी होते तो शायद यही करते, बिकॉज दैट इज देयर इज अटमोस्ट रिक्वायरमेंट ऑफ दिस वेरी लेजिस्लेशन. बिकॉज मैंने आपको बताया कि छुप छुपा के अबॉर्शंस तो वैसे भी हो रहे थे. सो व्हाई डोंट वी लीगलाइज इट? Why don't we have some proper law regarding that? Why don't we provide some better channel? Right? उससे क्या होगा कि ये जो एक स्टिग्मा के तौर पे देखा जाता है अबॉर्शन करना कराना, तो वो भी एक खत्म होगा, जो कि एक फियर निकालना है, एक इनहिबिशन निकालना है किसी भी वुमेन के मन से, वो भी निकलेगा. So there is certain lot of benefits arising from this very act. You must appreciate that. So I am repeating again clause B because this section 3 is important. Section 3 से बहुत सारा सवाल आपका बन सकता है, इसलिए यहीं पे इसको फाइनल करिए. Where the length of the pregnancy exceeds 20 weeks but does not exceed 24 weeks in case of such category as women as may be prescribed by rules made under this act. So, आपको पता चल गया कौन से वो रूल्स हैं, मैंने आपको डिटेल में बता दिया. Thereafter, if not less than 2 registered medical practitioners or of opinion formed in good faith. So, what is the requirement? यहाँ पे एक extraordinary 2 registered medical practitioners should be there if your case falls within 3B of medical termination of pregnancy rules 2003. If your case falls within when your pregnancy has exceeded what 20 weeks and it has not been exceeded 24 weeks. अब आप पूछेंगे क्या 24 weeks के बाद नहीं करा सकते? इट मीन्स आपके दिमाग में ये सवाल आना चाहिए कि क्या 24 weeks के बाद नहीं करा सकते. सो दिस हैज बीन टेकन केयर ऑफ थ्रू 2021 अमेंडमेंट एक्ट। 2021 अमेंडमेंट एक्ट ने तो पूरा चेहरा ही बदल दिया इस एक्ट का, राइट? जहां पे भी required था to enlarge the very scope of this act, they have done that thing. They have very successfully achieved that thing. So they are writing what formed in good faith. So those two medical practitioners should form their will, should give their consent, should be performing that very abortion, or should be advising in good faith that the continuance of pregnancy would involve a risk to the life of pregnant woman or of a grave injury to her physical or mental health. ये भी कंडीशन थी, इफ वी कंटिन्यू, इन दो मेडिकल प्रैक्टिशनर्स को ऐसा लगता है दैट इफ वी कंटिन्यू विद सच काइंड ऑफ प्रेगनेंसी इट वुड बी वेरी हार्मफुल फॉर द लाइफ ऑफ, इट वुड बी द रिस्क फॉर द लाइफ ऑफ दैट वुमेन, उस महिला के लिए ही ये जानलेवा हो सकता है। नेक्स्ट, देयर इज अ सब्सटैंशियल रिस्क that if the child were born it would suffer from any serious physical or mental abnormality। ये मैंने आपको ऑलरेडी बता दिया था। दो चीज, खुद मां के लिए ही वो खतरनाक हो जाए, उस प्रेगनेंसी को रिटेन करना, राइट, कंटिन्यू करना, ये मेडिकल प्रैक्टिशनर्स को समझ में आना चाहिए। अगर ऐसा लगता है तो यस दे कैन टर्मिनेट। सेकेंड सिचुएशन क्या है कि अगर उस चाइल्ड को हम there is a substantial risk that if child were born, child अगर born होता भी है तो that he or she will not be the normal child, he will suffer from any serious physical or mental abnormality। सो इस तरीके से हमने जाना 20 वीक्स तक कब प्रेगनेंसी को अबॉर्ट कर सकते हैं, टर्मिनेट कर सकते हैं, और 20 वीक से लेके 24 वीक्स तक कब हम टर्मिनेट कर सकते हैं। सिंपल। तो जस्ट रिमेंबर रूल 3B, जस्ट रिमेंबर टू कंडीशंस गिवन इन दिस वेरी सेक्शन इटसेल्फ, दैट इज it will be a risk to a woman itself if we continue with that pregnancy. It would be a risk to that child as well if he or she comes into this life, comes into this world, he or she will not be the normal child। simple। याद कर लीजिएगा मेरे साथ ही। अब one question can be asked, क्या ऐसी कोई सिचुएशन है जिसमें आपको टर्मिनेशन ऑफ प्रेगनेंसी अलाउ किया जाएगा? प्रेगनेंसी कैन बी टर्मिनेटेड इन एनी सच सिचुएशन वेयर इन फेल्योर ऑफ कॉन्ट्रासेप्टिव डिवाइसेस वाज द केस। सपोज करो कॉन्ट्रासेप्टिव डिवाइसेस वर यूज्ड बट इट गॉट फेल्ड, देयर आफ्टर दैट चाइल्ड केम इनटू दैट वूम्ब, child came into that womb। now in that case will that termination of pregnancy, such kind of pregnancy will be allowed? It is given in very beautifully answered in explanation 1. That is where this section becomes wholly important। Explanation 1, I am reading it for you। For the purposes of clause A, where any pregnancy occurs as a result of failure of any device or method used by a woman or her partner, for the purpose of clause A, clause A, it means less than 20 weeks, less than 20 weeks। बहुत ध्यान से समझिए। For the purposes of clause A, it means this case falls in the situation wherein pregnancy is there for less than 20 weeks, where any pregnancy occurs as a result of failure of any device or method used by a woman or her partner, right? For the purpose of limiting the number of children or preventing pregnancy, the anguish caused by such pregnancy may be presumed to constitute a grave injury to the mental health of pregnant woman। So they are using the word may। In explanation 1, they are using the word may। They are writing, अगर कोई ऐसी प्रेगनेंसी है जो बी क्लॉज ए में फॉल करता है आपका ये केस, तो उस केस में अगर कोई कॉन्ट्रासेप्टिव मेथड्स फेल कर गया इन ऑर्डर which those couple have adopted for the purpose of limiting the number of pregnancy, limiting the number of children, preventing the pregnancy, and that got failed and the child came into that womb। Now the anguish caused by such pregnancy may be presumed to constitute a grave injury to the mental health of pregnant woman। because that would be an unwanted child, right? Whenever they were entering into that intercourse, they didn't want that child, but thereafter somehow the due to the failure of that contraceptive method, contraceptive device, that child unfortunately came into that womb. Then in this case, will that be permissible to terminate such kind of pregnancy? Yes, yes, if your case falls within clause A. Clause A does not exceed 20 weeks, but with only with the advice of one medical practitioner. But there is one more condition. This kind of pregnancy, when the child came into that womb, it may be presumed to constitute a grave injury to the mental health of the pregnant woman. Now that pregnant woman is happy thereafter, if the child came into that womb, into her womb, now she is happy that okay, if even though it is unwanted child, then also I am happy, I'll bear this child. So this case will not fall in such kind of situation. Where it will fall when it may be presumed to constitute a grave injury to the mental health of the pregnant woman. तो ग्रेव इंजरी कब होगी टू द मेंटल हेल्थ? जब नहीं चाह रहे हो ऐसी कोई प्रेगनेंसी, ऐसे कोई बच्चे को आप जन्म देना नहीं चाह रहे हो, उस केस में मेंटल इंजरी की बात की गई है. जब आप हैप्पीली उसको वेलकम कर रहे हो, हैप्पीली एक्सेप्ट कर लिया आपने, then there is no any problem into that, and this very case does not fall within the explanation 1. तो आपको 2-3 कंडीशंस याद रखनी है एक्सप्लेनेशन 1 के एप्लीकेशन के लिए भी. एक्सप्लेनेशन 1 के एप्लीकेशन के लिए भी मेंटल इंजरी, a grave injury to the mental health of pregnant women can be presumed, right? They have used the word may. Now in explanation 2 they have used the word shall. क्यों ऐसा? क्योंकि यहां तो आपके आपस की बात थी, between the partners. They have used the word partners. Earlier they used the word before the amendment. I am telling you hereby, amendment से पहले 2021 amendment से पहले they were using the word husband. So again there was a very narrow scope. By using the word partner, they are just expanding the whole scope of this very act. Why to give protection only to married women? Why don't you give protection to all women? Simple. That is where Article 14 comes into protection. Constitutional guarantee of right to equality in equal circumstances, like should be treated alike, right? So explanation 2, for the purpose of clauses A and B, in any case 20 वीक से पहले या 20 वीक से बाद, किसी भी केस में कैसी भी प्रेगनेंसी हो, for the purpose of clause A and B, where any pregnancy is alleged by a pregnant woman to have been caused by rape. रेप हुआ था, उसके बाद that woman got pregnant due to that rape, and that now it is very obvious, that is why they have used the word shall, right? The anguish caused by the pregnancy shall be presumed to constitute a grave injury to the mental health of pregnant woman. It shall be presumed by the court that yes. अब यहां प्रूव करने की बहुत ज्यादा जरूरत नहीं है. अब anybody if alleges that this is illegal abortion, then you must always prove, you can always prove that I am a rape survivor. Due to that rape, I got pregnant, and thereafter it is immaterial how much time has been spent till now. अभी तक कितना समय बीत चुका है, इससे कोई आपका लेना देना नहीं होगा. 20 वीक या 20 वीक से बाद कोई भी टाइम बीत चुका हो. But it is very much clear that I didn't want to retain this child. That is why I have medically terminated this child, because I was a rape survivor and I was not ready to welcome this child, right? 2A is normal. They are writing the norms for the registered medical practitioner whose opinion is required for the termination of pregnancy at different gestation age shall be such as may be prescribed by the rule. Now they are using again and again gestation age. So you must remember that gestation is a fetal development period from the time of conception till the time of birth. Gestation is the fetal development period. जितने टाइम के लिए वो डेवलप होता है और जब तक कि वो बर्थ नहीं ले लेता है. Gestation is the fetal development period from the time of conception, when that child was conceived into that womb, right? जब कंसीव किया गया वो चाइल्ड, from the time of conception until the birth. कब तक? till the birth, जब तक कि उसका बर्थ नहीं हो जाता. 2b. now 2b, वन क्वेश्चन आई हैव आस्क्ड टू यू. सबसे आपसे मैंने एक क्वेश्चन पूछा था कि 24 हफ्ते के बाद का क्या सिनेरियो है. 24 हफ्ते के बाद क्या? 20 हफ्ते से पहले आपने जान लिया, 20 से 24 हफ्ते का आपने जान लिया. नाउ व्हाट आफ्टर 24 वीक्स? विल यू बी अलाउड? दैट वी आर गोइंग टू सी. द प्रोविजंस ऑफ सबसेक्शन 2 relating to the length of pregnancy shall not apply to the termination of pregnancy by the medical practitioner where such termination is necessitated by the diagnosis of any of the substantial fetal abnormalities. Section 3 2b, they are using the word any of the substantial fetal abnormalities. So this word hasn't been defined in this very act. कहीं पे भी ये एक्ट में डिफाइन नहीं किया गया ये वर्ड, लेकिन केस लॉस के थ्रू हम ये जानेंगे दैट व्हाट डज दिस वर्ड मीन. बट यू कैन ऑलवेज इंप्लाई दैट सब्सिक्वेंट सब्सटैंशियल, बहुत कोई सब्सटैंशियल फीटल, जो गर्भ में ही होने वाली तमाम समस्याएं, तमाम चीजें जो प्रॉब्लम्स होती हैं, दैट एबनॉर्मेलिटी हैज अराइजन. उस केस में इफ दिस एबनॉर्मेलिटी, ऐसी कोई भी समस्या मां के लिए अगर जीवन को के लिए खतरनाक या जानलेवा साबित हो सकती है, तो then yes, even after 24 weeks pregnancy can be terminated. But this will be decided by, not by the mother. Of course there will be a consent, but yes, they are writing shall, the provisions of subsection 2 relating to the length of pregnancy, because in subsection 2 we have seen 20 वीक से पहले, 20 वीक से 24 वीक के बीच में, और and all criteria which has been laid down in 3b of rules, medical termination of pregnancy rules 2003. so उन केसेस में उससे कोई मतलब नहीं होगा. The provisions of subsection 2 relating to the length of pregnancy shall not apply, क्योंकि यहाँ 24 वीक से हम, इसीलिए तो हमें ये पता चला कि ये 24, वो सारी situations, वो सारे periods apply नहीं हो रहे. It means they are talking about apart from 24 weeks, or if there is a case within that 24 weeks, अगर उसमें भी कोई जानलेवा स्थिति बनती है माँ के लिए, then yes, they can always terminate the pregnancy. But shall not apply to the termination of pregnancy by the medical practitioner where such termination is necessitated by the diagnosis of any substantial fetal abnormalities. Diagnosed by whom? Medical board. So this is where medical board comes into picture, itne baad mein, और medical board is very important in this. Now you can always read what constitutes medical board, कौन कौन लोग आते हैं medical board में. That has been decided by this state government. This is not very important, but you must remember that in this case, in case of subsequent substantial fetal abnormality, medical board has to play a very crucial role in deciding as to whether this pregnancy can be terminated or not. मेडिकल बोर्ड में कौन होगा? डॉक्टर्स होंगे ऑब्वियसली. मेडिकल बोर्ड, दे आर यूजिंग द वर्ड, वही तो डिसाइड करेंगे. कोई हम आप तो डिसाइड नहीं कर लेंगे दैट whether this pregnancy is going to dangerous for or very risky for the life of mother, woman. Okay, in 2c they are talking about section 3 2c, constitution of medical board. Constitution of medical board. Every state government or union territory, as the case may be, shall, they have used the word shall, so you must take care of this word, by notification in the official gazette, constitute a board to be called a medical board for the purpose of this act to exercise such powers and functions as may be prescribed by rules made under this act. Medical board in 2D, they are saying what constitute of medical board. Medical board shall consist of following, namely they have written certain things: gynecologist, pediatrician, radiologist, sonologist, and many kind of things. Whatever persons are required, what kind of doctors are required into determining that very pregnancy and issues related to that very pregnancy. Right? Now comes very important part, that is consent. How consent is important. Consent of a woman. No pregnancy of this, in this clause 4a, no pregnancy of woman who has not attained the age of 18 years or who having attained the age of 18 years is a mentally ill person shall be terminated except with the consent in writing of her guardian. It means consent of pregnant woman. If she has not attained, the age of 18 years, if she has not attained the age of 18 years, it means she is incapable of giving the consent. She is incapable of giving the consent if she has not attained the age of 18 years. Therein, the guardian comes into picture. Written consent of the guardian is required. Guardian is required. But if she has attained part, if she has attained the age of 18 years but is a mentally ill person, then what? Then also written consent of guardian is required. Guardian is required. Then also written consent of guardian is required. This was section 3, clause 4, subclause A. There is one more clause, clause B. Clause B. They are saying, save as otherwise provided in clause A, no pregnancy shall be terminated except with the consent of pregnant woman. It means in case of her being of 18 years and not mentally ill person, then no termination will be done of any pregnant woman without her consent, if she is above 18 years of age, she is mentally okay, then why there is a need of any guardian to give consent? She herself is capable enough to give a valid consent. Without consent, so I have given you sufficient notes on that. Okay, so there is one case, X versus the principal secretary health and family welfare department GNCTD. This you can take as government of this National Capital Territory of Delhi and others. This is of 2022. X. Why is there written this X? Because we don't have to disclose the very name of that thing, that pregnant woman. So appellant is an Indian citizen and is a permanent resident of Manipur. She is currently residing in New Delhi, and the appellant averred that she is eldest among 5 siblings. Just listen. And that her parents are agriculturists. The appellant is an unmarried woman aged 25 years and had become pregnant as a result of consensual relationship. The appellant wished to terminate her pregnancy, and her partner has refused to marry her at the last stage. She stated that she did not want to carry the pregnancy to term since she was wary of the social stigma which I was talking about, and harassment pertaining to unmarried single parents, especially women. Moreover, the appellant submitted that in the absence of source of livelihood, she was not mentally prepared to raise and nurture the child of an unmarried mother. So this was her contention, right? Thereafter, this appellant again sought permission to terminate her pregnancy under section 32B of Medical Termination of Pregnancy Act 1971 and 3B of Rule C of Medical Termination of Pregnancy Rules 2003. You remember 3BC, in that very rule it was given change of marital status. That is why I have said at that point of time they have enlarged the scope. Now this woman wants that her case should fall within this very rule कि marital status change हो गया या मैं चाहती थी उससे शादी करना, we entered into a very consensual sexual intercourse. Now she that partner is denying from marrying. अब ये चाहती है कि मेरा केस इस पर्टिकुलर सिचुएशन में फॉल हो जाए 3B के सब रूल C में, जहां पे मैरिटल स्टेटस या चेंज होने की बात हो रही है. तो अब कोर्ट को देखना था कि क्या ये केस इसमें फॉल हो सकता है या नहीं. By its order, High Court observed that 32B of MTP Act was inapplicable to the facts of the present case. Was inapplicable, mind you. This High Court found that this very situation, this very condition of the woman, which she wants that her case should fall under section 32B of MTP Act, was inapplicable to the facts of the present case, since the appellant being an unmarried woman, and they are specifically talking about married woman, marital status. भाई पहले शादीशुदा थे, अब डिवोर्सी हो गए, डिवोर्स हो गया, तो then there is a marital status. पहले शादीशुदा थे, husband is no more, now again there is a change of marital status. But in this situation there is no marriage existing, marriage ही नहीं है, there is a pregnancy without a marriage. In this very case there High Court denied to apply her case in this very rule. The order of the High Court gave rise to the present appeal to the Supreme Court. Now, in Supreme Court, it was allowed by giving a expansive interpretation to this marital status word, right? They have held that we cannot confine to this word marital status. There can always be material change in the circumstances, and we can't let the such kind of women suffer with that pregnancy. Okay, a change in material circumstances may also result when a woman is abandoned by her family or her partner. This is also a material circumstance, change in material circumstances. There can be several examples. आप याद करने के लिए सुन सकते हैं. For instance, it is not unheard for a woman to realize that she is pregnant only after the passage of 20 weeks. ऐसा अनसुना नहीं बात है, नई बात नहीं है. बहुत लेट में जाके पता चल पाता है किसी भी महिला को कि yes, she is pregnant. फिर उसके बाद इन केसेस में क्या होना चाहिए? इन केसेस में she is not at fault. Why she alone should bear all the brunt? Simple. Other examples are if woman loses her job and is no longer financially secure, or if domestic violence is perpetrated against her, or if she suddenly has dependents to support. Moreover, a woman may suddenly be diagnosed with an acute or chronic or life-threatening disease. Now suppose she is pregnant and she has been diagnosed with life-threatening disease. So should she carry that child? No, because it will ultimately be life threatening for that child as well. So in सारी situation को कैसे deal करेंगे? That is why Supreme Court played a very vital role in this very case, and they have made it inclusive, this very clause of every others this kind of examples of similar nature, जहाँ पे कोई marital status नहीं था, लेकिन इन जैसी स्थितियां अगर होंगी तो yes, it can be seen whether at least फॉल तो किया जा सकता है ना इस पर्टिकुलर क्लॉज में. अब नाउ लेटर ऑन मेडिकल बोर्ड विल सी, प्रैक्टिशनर्स विल सी व्हाट शुड बी डन, वेदर द प्रेगनेंसी शुड बी रिटेन्ड और वेदर द प्रेगनेंसी शुड बी टर्मिनेटेड. दैट इज अनदर थिंग, बट फर्स्ट एंड फॉरमोस्ट थिंग इज दैट टू डिसाइड एज टू वेदर योर केस फॉल्स विद इन दिस रूल और नॉट. 3B 7 क्राइटेरिया जो दिए गए थे, रेप एंड माइनर, इंसेस्ट एंड ऑल अदर थिंग्स, मेंटली चैलेंज्ड, फिजिकली चैलेंज्ड, माँ के लिए खतरा, बच्चे के लिए खतरा, बच्चा अगर आगे कभी जस्ट आता है अगर, तो वो कैसा होगा, he or she will not be a normal child. In that situation, in those situations, these all things have to be seen, and they have expanded this very approach. So the benefits in law extend equally to both single and married women. Single and married women. So this very case is a landmark case now, right? In this Article 14, Article 21, everything was discussed. Everything was discussed. Now I'll give you one chart in order to explain as to how this become very easy, how this become a cakewalk for you. 20 weeks, 24 weeks, ये आपको याद हो जाएगा उसके बाद. I'll be taking the stage before 97, this 2021 Amendment Act and post 2021 Amendment. Amendment. Post 2021 Amendment Act. Time period. आपसे सवाल पूछा जा सकता है सीधा सीधा, इस पर्टिकुलर टाइम पीरियड में क्या होना चाहिए? टर्मिनेशन ऑफ प्रेगनेंसी कैन बी डन, शैल बी डन, So it is based upon certain circumstances. Such kind of options can always be given to you. So you must prepare yourself as per those options, according to those options. Until 12 weeks. फर्स्टली 12 सप्ताह की बात की गई है. तो इन इसको आप ऐसे भी लिख सकते हैं कि 1971 में तक क्या होता था. 1971 का एक्ट जो कहता था ओरिजिनली, राइट, प्रायर टू 2021 का एप्लीकेशन से पहले 1971 ही अप्लाई हो रहा था. तो उस रिस्पेक्ट में समझेंगे. termination could earlier termination could only be done on the advice of one doctor. Now 12 to 20 weeks, same thing applicable, but termination could only be done but with the only with the advice of 2 doctors. So this was the situation before 2021 Amendment Act. And now they are clubbing these 2 periods after 2021 Amendment Act, and they have included both this situation plus this situation, and they are saying in both these situations, in both these situation, yes, termination of pregnancy can always be done. जितनी टर्मिनेशन अर्ली होगा, ऐसे सोचो, तो उतना इजी होगा. जितना लेट होता जाएगा उतने कॉम्प्लिकेशंस आते जाएंगे, ये आपको भी पता है. इन बोथ दीज सिचुएशंस एडवाइस ऑफ ओनली one doctor is required now. अब एक डॉक्टर की ही रिक्वायरमेंट है, राइट, इन बोथ दिस सिचुएशन. 12 वीक से पहले 12 से 20 वीक तक. नाउ देयर आफ्टर ट्वेंटी टू 24 वीक्स. टर्मिनेशन could have been done, उस समय किया जाता रहा होगा, तभी किया जा सकता था, only to save the life of pregnant woman, right? This was the case prior to 2021 Amendment Act. But what is there after Amendment Act? Termination can still be done. ऐसा नहीं है कि मना कर दिया गया कि अब नहीं कर पाओगे. आपने देखा है, मैंने आपको बताया कि 24 वीक के बाद भी हो सकता है, बट सब कुछ आपको प्रोविजन के थ्रू मैंने सारा कुछ आपको अच्छे से बता दिया. नाउ आई एम मेकिंग इट इजियर फॉर यू, कि जिससे आपको याद रहे, रिटेन रहे. टर्मिनेशन कैन स्टिल बी डन बट ओनली ऑन द एडवाइस ऑफ, नाउ they have included advice of 2 doctors. 2 doctors plus, and that too when woman will always be a pregnant woman. In this very case, you can always write when woman falls in either category given in rule 3b of MTP rules 2003. So this I have dealt in detail. Later, after 24 weeks, what is the scenario? After 24 weeks, what was the scenario and what is presently the situation? So earlier, prior to 2021 amendment, termination of pregnancy could only be done before 2021 amendment. You write, or you just write simple, done only to save the life of woman, and there were no conditions for that, extra conditions. But now termination after 24 weeks, termination after 24 weeks can only be done after the approval of medical board, under section 3 2b, and that too only in the cases if there is substantial fetal abnormality. So whatever I have told you, I have written here. That is important. The substantial fetal abnormality. So this is clear. I hope this will be helpful for you. Now you write in which case this substantial fetal abnormality was X versus GNCTD and others. GNCTD you can refer as this Government of NCT Delhi. It is again 2022. So court through, this was nowhere defined in this MTP Act, substantial fetal abnormality. So that is why court threw light on the term substantial fetal abnormality. In this case, the court took guidance from reliable external sources as to what would constitute substantial fetal abnormalities, right? A report, कहाँ से इन्होंने नॉलेज ली इस बात की, गाइडेंस कहाँ से लिया? रिपोर्ट टाइटल्ड टर्मिनेशन ऑफ प्रेगनेंसी फॉर फीटल एबनॉर्मेलिटी इन इंग्लैंड Scotland and Wales by the Royal College of Obstetrician and Gynecologists, which analyzes the risk and gravity of fetal abnormality and advises that the following factors could be considered to determine the gravity of the same. So you just give it a reading, that would be sufficient, and you'd remember this case wherein it was discussed, this substantial fetal abnormality. Now you come amendment of 2021. What are the changes been made? Those changes were related to the time period, कब हम pregnancy terminate कर सकते हैं, कब हम नहीं कर सकते हैं. But other changes are there as well. Other changes are there as well. First, it permits abortion with the assent of one medical practitioner within 20 weeks. This you already know, within 20 weeks. Two medical practitioners for 20 to 24 weeks. This you already know as well. In place of by any married woman or her husband they use the word substituted, you write, they substituted the word any woman or her partner and the very important thing you can write, this amendment also includes unwanted pregnancies due to the failure of contraceptives as a ground for abortion, as a ground for abortion. तो एक बार समराइज करा देता हूं. 1 में आपने सब कुछ देख लिया था, शॉर्ट टाइटल, एक्सटेंट एंड कमेंसमेंट. सेकंड, डेफिनेशन क्लॉज, you have exhaustively seen. Thereafter, third clause was very important for you, in which you have seen several things which was important for you. Fourth, you can read on your own, but yes, section 5 is important. They are talking about the same thing which we have discussed, but you must know. In section 3 and 4, when not to apply, whatever you have read in section 3 or 4, 3 और 4 में जो भी आपने पढ़ा कब नहीं एप्लीकेबल होगा, अभी तक जो भी पढ़ा वो कब नहीं एप्लीकेबल होगा सेक्शन 5 में. क्या है ऐसा सेक्शन 5 में? The provisions of section 4 and so much of the provisions of subsection 2 of section 3 as relate to length of pregnancy and opinion of not less than 2 registered medical practitioners shall not apply to the termination of a pregnancy. सुन के कैसा लग रहा है कि जो भी अभी तक पढ़ा वो एप्लीकेबल नहीं है सेक्शन 5 में. कब? अब आप ये जान लीजिए शॉर्ट में. सो इररिस्पेक्टिव ऑफ एनी लेंथ, 20 weeks, 24 weeks, 12 weeks, nothing is material here. Irrespective of any length, irrespective of taking advice of the doctors, अगर कहीं पर किसी भी मेडिकल रजिस्टर्ड प्रैक्टिशनर को ऐसा लगता है कि वुमेन को इमीडिएट लाइफ रिस्क है, वुमेन को इमीडिएट लाइफ रिस्क है, तो वो 3 और 4 के सेक्शंस को फॉलो नहीं करने जाएंगे. रादर दे विल गो ऑन टू सेव द लाइफ ऑफ द वुमेन, राइट, सेव द लाइफ ऑफ द वुमेन. एंड while doing so in good faith in terminating such pregnancy, अगर प्रेगनेंसी को टर्मिनेट भी करना पड़े, right, then they will not be held liable and there will not be any action taken against them. ये था सिचुएशन. 5 कब नहीं अप्लाई होगा? जब देयर विल बी अ वेरी रिस्क ऑफ लाइफ एंडेंजरिंग सिचुएशन फॉर द वुमन. सो दिस वाज द केस. यू कैन ऑलवेज रीड इट ऑन योर ओन. देयर आफ्टर पेनाल्टी, सब में देखो 2 से 7 साल है, तो इसमें याद आपको नहीं करना है, एक जगह से सिर्फ अलग है, तो मैं आपको बता देता हूं. नॉट इन सेकंड क्लॉज नॉट विथस्टैंडिंग एनीथिंग कंटेन्ड इन आईपीसी, द टर्मिनेशन ऑफ प्रेगनेंसी बाय अ पर्सन हु इज नॉट अ रजिस्टर्ड एमपी मेडिकल प्रैक्टिशनर शैल बी एन ऑफेंस पनिशेबल विथ रिगरस इंप्रिजनमेंट. तो ये क्वेश्चन आ सकता है वेदर दैट इंप्रिजनमेंट विल बी सिंपल और रिगरस. तो रिगरस होगी. रिगरस कितनी? एट लेस 2 साल से कम नहीं और 7 साल से ज्यादा नहीं. ठीक है. फिर अगेन इन थर्ड क्लॉज दे आर अगेन यूजिंग द सेम सिचुएशन, सेम पनिशमेंट. whoever terminates any pregnancy in a place other than mentioned in subsection 4, subsection 4 के वायलेशन, सेक्शन 4 के वायलेशन में अगर कोई टर्मिनेट करता है प्रेगनेंसी को, then again it will be punishable with minimum number of imprisonment, that is 2 years, which may extend to 7 years. Thereafter ओनर का डेफिनेशन आप देख लेना इसमें, राइट. उस जो ओनर है उस प्लेस का जहां ये सब चीजें की जा रही हैं, टर्मिनेट किया जा रहा है, तो देन अगेन ही विल आल्सो बी लायबल फॉर द सेम पनिशमेंट 2 to 7 years. प्रोटेक्शन ऑफ प्राइवेसी ऑफ अ वुमन, ये आपसे पूछा जा सकता है. वहां पे आप से ये भी पूछा जा सकता है किस पर्टिकुलर केस लॉ को आप यहाँ पे केस लॉ से असिस्ट होना चाहेंगे. दैट इज केएस पुट्टा स्वामी केस. यू मस्ट रिमेंबर दैट. Protection of privacy of a woman. No registered medical practitioner shall reveal the name and other particulars of women whose pregnancy has been terminated under this act, except to a person authorized by any law for the time being in force. और अगर इसका भी कोई violation करता है, तो there will be a punishment, but yes, lesser punishment is there. Shall be punishable with imprisonment, which may extend to 1 year, or with fine, or with both. रूल बनाने का अधिकार किसको दिया गया है? सेंट्रल गवर्नमेंट को. रूल बनाने का अधिकार सेंट्रल गवर्नमेंट को. और जिस तरीके से और सारे माइनर एक्ट्स में हमने पाया था कि जो भी पब्लिक सर्वेंट दिए गए हैं उनके द्वारा अगर कोई भी एक्ट होता है इन गुड फेथ प्रोसिक्यूशन ऑफ दिस, they will not be prosecuted if they have taken any action in this very act in the similar way as they were taking actions in other acts like DV Act, like Maintenance of Welfare and Parents Act, Indecent Representation Act, if you all remember. So they have given the protection to these kind of officers. Protection of action taken in good faith. No suit or other legal proceeding shall lie against any registered medical practitioner. So here there is no any public servant, rather doctors are here. Registered medical practitioners are there. So they will not be held liable for causing any damage or likely to cause damage by anything which is in good faith done or intended under this act. So I hope this very act is complete and you just give it one reading, revise it properly and make a short note of it and retain it till the exam at least. Okay, thank you so much.